You may have seen in the news that Tommy Robinson, or Stephen Yaxley Lennon, as the court calls him, has been knocked back in his application for judicial review about his status in prison. So what I thought I'd do is I would just go through, because I've now managed to get the full written judgment. So I'll just sort of go through the key points. I mean, I'll link to the actual full judgment in the description and you can see for yourself. So obviously I'm not going to give any of my opinions on this because I don't really have any. But I thought I'd just explain, what the court have said. And then, like I say, it's up to you to decide whether you think that's right or not. So first of all, what was this about? Well, he brought a judicial review about his current status in prison. And what he said is, and to quote from the judgment, the claimant in this case is Stephen Yaxley Lennon. He's currently detained at HMP Woodhill. He seeks permission to apply for judicial review of what he describes in his claim form as his, quote, ongoing detention in solitary confinement and treatment, unquote. He contends that this is incompatible with his rights under Articles 3, 8 and 14 of the European Convention on Human Rights, and therefore contrary to Section 6 of the Human Rights Act 1998. In addition, he challenges his continued segregation on public law grounds. So first of all, what's judicial review? I've done quite a few videos on this, so just search in the channel, just type judicial review and that will explain. But effectively, it's a way of challenging the decisions of public bodies. And that includes prisons and the prison service. I do have some actual experience of JRing prisons. I think I mentioned it before, where it's a nightmare because technically you have to bring the JR against the actual prison somebody's detained in. So every time we sent the letter before claim off, they just move my client. In this particular case, though, they've just gone for the Secretary of State for Justice as being in charge of the prison system as a whole. And you can actually do that. But before you can apply for judicial review, you have to get permission. It's a bit like appealing, where you need permission or leave to appeal before you go on to the substantive appeal. And what the court here said is, well, we'll hear the application for permission. Now, what's interesting is they didn't order what we call a rolled-up hearing, because sometimes they will list a case, and this is a really good indicator of what they're thinking, what the court's thinking. They will say, we will list the permission application with the full application to be heard immediately afterwards if we grant permission. And that's usually a sign, it's not always, it's not a definitive indicator, but it's usually a sign that they think there is some merit in this. And quite often, of course, you make all the fundamental arguments in the leave application. So when it comes to, yes, we're going to give you leave for the judicial review, what do you say? You say, well, I just repeat what I've just said. But in this particular case, they actually said, no, we'll have just a permission hearing first. So that was done, and they put in lots of arguments basically about his position, and there were experts' reports from prison psychologists and people like that, and from people running the prison. But he was knocked back, and I'm going to read, and this is quite a lengthy statement, but I think it's as good a summary as I can imagine. So I'll apologise for looking down. I know a lot of people say I've always got a dry mouth, which is true, so I'm just going to have a quick swig of coffee. Oh, lovely. That would have been nicer about 2 hours ago when I actually made it. I've got this habit, it's that typical English thing, it's like I'll make a cup of tea and then I'll forget about it and then find it hours later. But anyway, here's what the judge said. First, as Mr. Williamson accepts, that's Tommy Robinson's counsel, there is nothing to suggest that the decision to segregate Mr. Yaxley Lennon was taken for the purpose of breaking his resistance or humiliating or debasing him. On the contrary, all the evidence shows that it was taken for his own protection and in the interests of preserving the safety of other prisoners and staff. It was not mere speculation that he would be at risk from Muslim prisoners. He himself had said, when first detained at HMP Belmarsh, that he had a conflict with the followers of Islam. On 13th of November, at HMP Woodhill, when the prospect of a move to the main part of the prison had been mooted, he mentioned that the significant number of Muslim prisoners. It was thus understandable that the governor should be concerned that Mr. Yaxley Lennon's presence might foment unrest or violence between Muslims and non-Muslim prisoners. There was also specific intelligence of two potential threats to him, one of which was a threat to his life. So as I've said previously, when people say, oh, why was he segregated? Actually, at the sentence hearing, and this was for the contempt of court for breaching the injunction about not repeating some allegations that had been found to be defamatory. But it was mentioned in the sentence hearing by his own counsel, said, look, he will have a tough time in prison because of who he is. He's got a target on his back. And the judge said, I accept that. Now, just to explain the different roles, all judges do is impose sentence. The actual prison regime, what category you're in, how they treat you, how they do, whether you're eligible for early release under the various schemes, that is wholly the remit of the prison service. Judges at the sentencing stage can't interfere with that. They can't impose any rules themselves. But you can, of course, challenge the prison regime through the judicial review process. But what the court is saying here is, look, even Robinson's own legal team said, he is at risk and he needs to go into... It's not quite solitary. And again, I've done a video on this, you Google for it, about exactly the regime he's being held under. So it's not solitary confinement. It's basically, it's a thing called Rule 45 now, where if it effectively, it used to be the old Rule 43, but it's where there's a special enhanced regime for potentially vulnerable prisoners. And that can be people who are controversial. It's quite often used for like informants or ex-police officers, people like that. But it's not solitary confinement. It's being not held in general population. And it says, secondly, the decision was regularly reviewed in accordance with Rule 45 and with the applicable policy documents. I mean, I've mentioned this before, that you have to have like a review after 15 days, and then you have to keep reviewing at regular intervals to say, is this still necessary? Because it's accepted that it's not necessarily as nice a regime being held on Rule 45 as it is being in general population. But it says each such review involved input from an NHS clinician. The outcome of each review was properly recorded. The Governor of H&P Woodhill has given detailed evidence in response to the claim, setting out the reasons for the decisions she made. There is and could be no challenge to the veracity of those reasons, not least because his own legal team are effectively agreeing with them. Thirdly, there are several aspects of the regime which ameliorate, that's a hard word to pronounce, have a coffee for that, which ameliorate, I should have stuck with the first attempt, the effects of segregation on Mr. Yaxley Lennon. He is permitted some 3 hours per day out of his cell, which is more than twice the time allowed to convicted prisoners held in segregation. He can use the gym and shower every day. He has recently started work, which gives him some additional time out of his cell on some weekdays, albeit still on his own. He has 2 hours for visits from friends and family 4 times per week. He has 4 hours per day for telephone calls to friends and family and uses these. He speaks to prison officers, healthcare staff and staff from the chaplaincy daily, and has a weekly Bible study session. Such a regime is very far removed from those found to violate Article 3 in the case law. Article 3 is the right, that's the ECHR, and that's the right not to be subjected to, well, actually it starts off at torture, but torture or degrading or oppressive or humiliating treatment. Fourthly, Mr. Yaxley Lennon's mental health is properly and regularly monitored by professionals from the Prisons Psychology Service and the NHS. He is visited every day by an NHS doctor or nurse. His treatment plan has been formulated with input from a senior forensic psychologist and a consultant psychiatrist. Dr. Connelly's report has been considered and taken into account by them. That was another psychiatrist who wrote a report. So he wrote a report and then other psychiatrists have chipped in and said, well, actually, they just said, we agree with it. We agree with the assessment. Fifthly, Mr. Worsman's witness statement makes clear there's been a careful consideration of the alternatives to H&P Woodhill. That was a witness statement from somebody at the prison, just saying, look, this is how we've reviewed his detention. Careful consideration of alternatives to H&P Woodhill. Category B dispersal prisons would be inappropriate because the same or greater risks would arise there. A dispersal prison is when you are first convicted, before they work out where the best place to keep you is, because they do all the assessments. There's a system called OASIS, spelt with a Y, which examines your offending pattern, takes into account all your personal circumstances and plans a scheme, a regime when you're in there. So it might be something like, you're going to be in here for 14 months or 12 months or 6 months. It might help, you might need psychological counselling, you might need anger management. It could even be stuff like, we just need to train you up so you've got some skills so you can get a job when you're outside. It's as wide a sort of remit as that. But a dispersal prison is where they do those assessments, and then they say, right, you're going to be in for 10 years, so we'll send you off to some long-term prison on the Isle of Wight. Parkhurst, for instance, generally only takes people who've got sentences of 10 years or more. I mean, I've actually been to Parkhurst, and it's weird because it's on the site of an old Roman villa, and in the main room, they've done it all out as if it's a Roman villa. It's actually quite nice, and generally speaking, because people are there for a long time, they tend to look after it themselves, whereas in dispersal prisons, it's all full of remand prisoners as well. So everybody's nomadic, nobody cares, because they're not going to be staying there very long, so they tend to be pretty horrible places. Whereas in Parkhurst, it was interesting. And the other thing that was good there is the prisoners cooked all the food themselves, as they quite often do, but they had a rota. So it'd be like, one night all the Jamaican guys would cook, another night all the Colombian guys would cook. I mean, my chap was Peruvian, so he went in with the general South American importers population. But they'd all do sort of different food and things, and it's quite interesting because my guy, in the time from the sentence, his conviction, to the time I could get to see him to discuss the appeal, he put on about like 9 stone. I was actually chatting to the jailers, and they were saying, well, it's great, prisoners full of nice food tend to be sort of like a lot more cooperative. And also I was going like, well, he certainly can't squeeze between the bars anymore, and I wouldn't trust him up a ladder. I did actually make a joke, because this was just after some pyro guys had escaped. They'd built a, quote, bookcase in the metalworking room that basically just transformed into a ladder, and they just hopped it over the wall. I mean, the thing with Parker, so you're stuck on the Isle of Wight, so you just stand out anyway. So they were soon recaptured. But I did make a bit of a joke about them not being able to spot. So did you not find it suspicious that this bookcase was like 12 inches wide and 24 feet tall? And they didn't take that very well, it has to be said. But yeah, that's the difference between a dispersal prison and the prison you ultimately end up in. And it might be something like, you're clearly not a risk, we can Cat D you and we can just put you in an open prison. So those are the sort of assessments they do. But they said also they couldn't put them in a Cat C prison because they have low staffing ratios and more transient populations, making the risk more difficult to manage because you just don't know who's coming in or out, or who's got a grudge, or who's got nothing to lose, or who wants to make a name for themselves. Because that's the trouble, if you're some long-term prisoner and you're just bored, it's always worth having a pop at somebody, especially if it's somebody notorious. I mean, we've had a lot of high-profile, controversial cases recently, and instantly you always get all the Twitter stuff going, oh, they've been attacked in prison, which is usually not true, and rage bait or wishful thinking or whatever. Because, the prison service do try to manage it. But yeah, obviously, there are risks, and it's how do you actually manage those risks. And they've said as a Category C prisoner, and they don't challenge that that's the correct designation for him, a Category D prison would not be a possible destination. So they say we can't put you in an open prison or one of these sort of like club fed, as they call them in the States, because you are Cat C, and it is accepted that you are properly Cat C. Cat D is when, they're getting you ready, you've been rehabilitated, you've been in there for years, you're all like that guy in the Shawshank Redemption going, I wish I could have spoken to that young kid back then and I'd just slapped some sense into him. It's the sort of, we can trust you to go to the shops and we know you'll come back. So that's what Cat D is. And they say, finally, it is worth noting that the conditions of Mr. Yaxley Lennon's detention are subject to challenge before an independent tribunal, namely this court. The challenge has been promptly and rigorously considered. So they're saying, because under the Human Rights Act, that incorporates the European Convention on Human Rights into English law, but it also says, and it's actually in the ECHR itself, it says these aren't just theoretical rights, you must have a way of enforcing them or challenging breaches of these rights. You have to have a right to a remedy, otherwise they're all pointless. And that was one of the grounds they put in and said, he's got no way of challenging this. And the court said, you're literally stood in front of us challenging it. So, we're not going to take that any further. So they go on and say, so those are the substantive reasons that they've been knocked back. And they say, in light of these features, it is not accurate to refer to Mr. Yaxley Lennon's regime as, quote, solitary confinement at all. I accept that the absence of association with other prisoners has an effect on his mental health, but it is not arguable that the regime as a whole gives rise to a breach of Article 3. As to the Article 14 point, they're saying the decision to segregate Mr. Yaxley Lennon was taken because of the risk to himself or others. So it's not saying it's not arbitrary. It wasn't an extra punishment, because the punishment element of a prison sentence is the deprivation of liberty. It's not, we're going to send you somewhere horrible where you'll have to watch yourself in the showers or you're going to get shanked at any given moment. The punishment is merely you are deprived of your liberty to some degree or another. But they're saying here, the fact that those risks arose because of his well-known political views does not mean that he has been adversely treated because of those views. So they're saying it's not because of your underlying views, it's the fact that your views have put you at risk. But is he being treated differently? And they say, well, the point can be tested by asking the following questions. Would the governor have segregated someone with quite different political views if those views led to similar risks to himself and others, and the risk could not be safely be managed without segregation? And on the evidence, which again says Mr. Williamson did not seriously challenge, there is only one answer: yes. In other words, what drove the segregation decision were the risks, not the ideology or perceived ideology which gave rise to those risks. So they're saying he's not being punished for his views, he is being protected for his own safety because his views make him a target. And says, that being so, this is not a case where Mr. Yaxley Lennon can point to any direct discrimination at all. The complaint is not put as one of indirect discrimination. If it were, it would be necessary to show that those espousing Mr. Yaxley Lennon's views were more likely to be accommodated in segregated conditions than those espousing other political views. There is, however, no evidence of this. Even if there were, any indirectly discriminatory treatment would be proportionate in view of the 5 features, those ones I've just mentioned, and the additional matters under ground 2. And they also look at it, commented on his mental health aspects. So they said, they put in an expert report from this Dr. Connolly. The judge allowed it to go in, said, I've read the report carefully. It does not say that Mr. Yaxley Lennon is experiencing a mental health crisis or is at risk of, oh God, the algorithm again. What do we call it? Self-deleting. Or self-harm. Nor does it say that a continued segregation is likely to lead to an imminent and significant deterioration of Mr. Yaxley Lennon's mental health. It does highlight the significance of Mr. Yaxley Lennon's ADHD and complex PTSD diagnosis. However, healthcare staff based at H&P Woodall and NHS mental health staff, including a senior forensic psychologist and a consultant psychiatrist, have taken full account of the diagnosis set out in Dr. Connolly's report in formulating his treatment plan. So what they've said is, look, we appreciate, you've got mental health issues, as probably have lots of the prison population, either before they went in there, or if you go in there for a long time, it's very easy to get a mental health condition. Because obviously, prisons are unpleasant places to be. But what they said is, look, they've taken everything into account. So that's the rationale for knocking him back. Effectively, they're saying, look, you could only do this you could only challenge this if you're saying, I am being arbitrarily punished because of my views. And what they're saying there is, first of all, you're not actually being held in, quotes, solitary confinement. You are allowed to move around, and in fact, you actually get better treatment. You're getting more, you get more rights and more allowances than actually your average prisoner. It's just the fact that there are limitations on who you can speak with. You just can't, we just can't risk you mixing with other prisoners. So you can talk to all the prison staff, and indeed, and they go into great detail in the judgment about the number of visits he's had and the fact that he's got extra phone call privileges and extra visiting privileges and all that sort of thing. I mean, I know people have said, oh, we're not allowed to see because there's NDAs. That's not quite true, but what it is, you're not allowed to use a sort of prison visit to carry on offending, as it were. So if somebody, if somebody came in, you get this a lot with organised crime figures, and it's like, we're not going to let you speak to that guy because he's basically running the gang while you're inside. You can talk about anything you want to, other than, why he's in there and how your legitimate or otherwise business is working. And what they've said here is, and the thing to remember is, and I know people have commented about, oh, is it fair that he's banged up? The fact is, there was a court case which he lost. He hasn't successfully appealed that. And as is very common in defamation, where people say this is just untrue, and I've done a full video about, the case itself, which you can go back at, they put an injunction there, and if you breach the injunction, it's not a defence to say, well, I think I'm right. If you think you're right, and you've got new evidence, appeal. That's what they're saying. They're saying, if you want to challenge this, appeal. And then we'll have a look at it. But it's not for you to say, I am going to ignore a court order just because I disagree with it. And, theoretically, that, well, it does apply to everybody. You might, be in a court case where you get a judgment saying you owe somebody some money. And you might disagree with it and say, no, I say that decorating job was rubbish. I don't see why I should have to pay for it. But that doesn't stop the tradesperson enforcing the judgment against you and sending the bailiffs round. If you think the decision was wrong, you can appeal it. So there you go. Like I say, I'll link to the full judgment. It's worth a read. I'd be very interested in all your comments about this. Now, one thing, I want to make one of my Mystic Owl predictions here. Because as you know, he was sentenced to 18 months in prison minus 3 days. And he'll serve half of that. So here's my guess. Because the judge said, if you wish to purge your contempt, I'll knock 4 months off that. And what is purging your contempt? Purging your contempt is remedying the thing that you got banged up for in the first place, which in this case is that documentary, the silence thing. And what they're saying is, most of it is unobjectionable, but you are within that repeating the allegations that you have been injuncted about repeating. So, you can make the judgment you can rant about how unfair it was and how badly you were treated and, how unjust it was and how you disagree with the decision. But what you can't do is repeat the allegations. So if you remove the actual allegations themselves, that's fine. And we'd say you weren't in contempt then. So my guess is that just prior to it coming up to that last 4 months, I think he will apply to purge his contempt. I think we'll suddenly get something going. I have now agreed that I will no longer do the video, release the video in its offending format. I will edit out the bits that are objectionable. And now I've done that, or now I've promised to do that, please can I be released early? So there you go. That's my Mystic Owl prediction for this. But just let me know what you think in the comments. I mean, I was going to... So, because I don't, there was a bit of a nothing burger in this from a legal point of view. It was just, somebody's been knocked back on a JR about their status in prison. And, sometimes, like I say, people do get that wrong. I've had a few recently where it was like, well, hang on a minute. Because what it was in that situation is they weren't abiding by their own recommendations. Their offender management unit and their OASIS team were saying you need to do this, this and this before we're going to put you in this category and allow you to do this. And the person did all that, and then they still didn't do it. So that was an arguable ground for judicial review, because it's like, well, what's your logical rationale for doing this? Bearing in mind, you said that if the claimant did this, then this would be the consequence. The claimant did that, and then the consequence didn't arise. So on that one, that did shift them a little bit. But we shall see. As always, hope you found that vaguely interesting, vaguely informative, vaguely accurate. Sorry I'm indoors again. I'm just so stacked up with work. I mean, I thought I turned my phone off. I put it on airplane for you probably hear it pinging away because it's picking them off on the Wi-Fi. And I think every one of those pings is another request for some sort of due diligence or anti-money laundering stuff, because I've got so much work on today. Due diligence. We used to be a country. What happened to people just taking a punt?